Start. The explanation within bracket 2 of clause within bracket C of section 2 as well as explanation within bracket 2 to subsection within bracket 3 of section 5 of the act, comma, being identical state that all rights, comma, titles, comma, and interest in, comma, are any benefit arising out of such enemy property vest in the custodian, full stop. This means that only the rights etc, comma, which enemy property vest in the custodian, full stop. By that, comma, the custodian does not acquire ownership rights in the property, full stop. On a conspectus reading of the aforesaid provisions, comma, what emerges is that under section 3 of the act, comma, the custodian of enemy property for India is appointed by the central government by issuance of a notification in the official gazette. So also deputy custodians and assistant custodians of enemy property could be appointed for certain local areas as may be specified in the notification, full stop. Since the act is in continuation of the Defence of India Rules, 1962 as well as Defence of India Rules, 1971, as the case may be, the custodian of enemy property for India appointed under the aforesaid rules shall be deemed to have been appointed under section 3 of the act, full stop. The proviso states that where an individual subject dies in the territories to which the act extends, any property which immediately before his death belonged to or was held by him or managed on his behalf, may, notwithstanding his death, continue to be recorded as enemy property for the purposes of this act, full stop. This proviso clearly recognizes that the death of an enemy would not result in the enemy property ceasing to be so, full stop. Explanation within bracket 1 to section 2 within bracket C also states that enemy property shall continue to remain as enemy property even on the death of the enemy or extinction, winding up of business or change of nationality to continue to remain an enemy property, full stop. This is even if the legal heir and successor is a citizen of India or a citizen of a country which is not an enemy country, full stop. Explanation within bracket 2 thereof states that enemy property shall mean and include and shall be deemed to have always meant and included all rights, titles and interests in or any benefit arising out of such property, full stop. This explanation gives meaning to the scope of the expressions belonging to, held or managed on behalf of an enemy, an enemy subject or enemy firm, full stop. If a certificate is issued by the custodian that the enemy property has vested in him under the act, the same shall be evidence of the facts stated therein, void section 5-A of the act, full stop. Section 5-B of the Act begins with a non-obstante clause which states that nothing contained in any law for the time being in force relating to succession or any custom or usage governing succession of property shall apply in relation to the enemy property under this Act, and no person within bracket including his legal heir and successor bracket close shall have any right and shall be deemed not to have any right within bracket including all rights, titles, and interests or any benefit arising out of such property bracket close in relation to such enemy property, full stop. This provision regarding extinction of rights, titles or interests or any benefit arising out of the enemy property is deemed to have been lost is by operation of law and by a legal fiction only insofar as a heir or successor is concerned, full stop. If any property is vested in the custodian as enemy property, then no enemy or enemy subject or enemy firm shall have any right to transfer any such property, and any such transfer shall always be deemed to have been void, full stop.